Okay, fantastic.
Okay, so I'm not going to try to pick up exactly where I was mid-sentence. I am not that good. I apologize. But, I was basically explaining that in contrast to the sort of easy test for transformative use of the Campbell soup can to the Andy Warhol depiction of soup cans, um, you run into a much more difficult question when you have a case like this, when both works are at a high level attempting to achieve the same purpose um, and can be, as we see, substitutes for each other in the marketplace. Um, and so what we proposed is a more explicit articulation of what it means to have a transformative use in those cases. And we propose that the second work has to extinguish, subvert, or subordinate the message of the first, and that should be judged from the perspective of an objective, reasonable, objective observer, and not as the Warhol Foundation wants it to be, just by the artist say so or some expert decades later say so of what the intent of the second artist was. Because in this case, the Warhol Foundation is saying, well, he was Andy Warhol when he added purple and orange and the effects was trying to make a comment on the nature of celebrity. It's like, okay, but I don't necessarily, does a reasonable objective observer actually see that when they look at this picture? And even if they do, aren't they still seeing beneath it the intent that Lynn Goldsmith initially had when she specifically posed Prince and did his makeup and captured him in a certain way? And so we think that that kind of more defined test would help courts dealing with these harder cases.
Yeah, and to pick up on that, on the doctrinal point that you were making at the very beginning, this crystallizes the problem of utilizing one approach for all transformation problems. And the distinction that we talked about when we were all sitting down trying to figure out, what did we want to do in this brief, was to distinguish between utilitarian transformation and aesthetic transformation. When you are focusing in on how the work is used, like the great example that you gave earlier, the way the expression is being used on a Campbell soup can to sell soup, well, that's a different utilitarian use than to make a statement on commercialism, right? Very much also the same in the digital information cases, right? Some artwork that you put out there for people to see on the internet, and then somebody else comes along and they are shrink it down to a thumbnail to create an index. You know, those are clear utilitarian distinctions. But as you were saying, when it's high art, right? To simply say, well, is there some other, message or what have you? And that's why, as we were working, because we had lots of conversations about this, and I think the original three words I used, and then you guys came and said, wait, no, this is. Oh wait, and then reminded me that one of those words they already use, but they use it for something different. So it took a lot of work for us to figure out how could we articulate this test. And can you say it again? Because it was so cool what you guys came up with.
It was subvert, subordinate, or extinguish.
Yeah, yeah. And that captured the fact that when you look at the new work, right, you have greater assurance that what it is that people are reacting to, what they're praising, what they're connecting with, what perhaps they're paying for, is some significant contribution on the part of the second comer, and not merely a misappropriation of what had been there in the first place.
So jumping in to react to that, my reaction is that very much seems to bring
the beneficial aspects of the substantial similarity analysis that I'm pushing for up into a fair use analysis, right?
Exactly.
Because what you want to see happen in a substantial similarity analysis is to understand what is wrongful from the appropriation.
Right.
And I think in a properly sequenced and properly carried out analysis, which, by the way, we see with other types of works, right? We see a substantial similarity analysis followed by a fair use analysis, typically. And for some reason, we're not seeing it in artwork cases, but we would get that result. We would get your results, right? So I think it's an interesting interesting alliance here, right? In some ways, we're both saying, please follow the law, right?
Exactly.
So the one thing that I was going to say is, and this kind of goes back to my point of courts not feeling comfortable with art. If you compare how much they struggled here with the better job that courts do in literary works, if you look at this was also, I guess, not it was a much talked about case, SunTrust Bank versus Hutton Mifflin, right? The Gone with the Wind, the Wind Done Gone case. There, Alice Randall copied extensively from Gone with the Wind. She didn't have a license. There was an active licensing market for sequels and adaptations of the work. But she prevailed, right? Because the work was a transformative social commentary or parody, right? And what happened? There was a very thorough substantial similarity analysis first, found out which elements were being taken. Were they copyrightable elements that were being used? And that was very important to the first factor analysis, right? You need to understand, like, we wouldn't have even had to look at whether it was transformative or not if she hadn't taken stuff that was already copyrightable, right? If the characters and the scenes and the phrases weren't for some reason rising to the level of copyrightability, protectability in some fashion, then we wouldn't have to worry about it, right? But they were, right? And so the court examined them and examined whether the use was to advance their social commentary, and it was, and so it was transformative. But it didn't end there, right? Then you go on to the third factor. And in the third factor, she also prevailed because not only was it for a parodic nature, but she used only as much as was necessary for her purpose, right? She didn't say, I'm taking it all. I'm taking, this is going to make my story more appealing and people will relate to it more. I'm advancing it's going to be easier for me to write this, right? Or people will relate to it more or remember it more or whatever. She took what she needed relative to what she was doing. And so that analysis can't occur here either, right? Without doing this first part of the test, right? Without first doing a substantial similarity analysis and understanding what is it that you're transforming, right? What are the facts here? So I think, again, we're sort of violently agreeing with each other, but calling it maybe different things, but agreeing.
Exactly, because your assessment of pointing out that, okay, well, first, we need to know what you're transforming, right? So what we're transforming is the message that we are utilizing these characters to get across. And to say it differently, talk about using the characters from the first work to totally extinguish the message of the first work.
And I would say subvert, right? Not just extinguish, but totally subvert it. And that's what makes it such an effective work on the part of Alice Randall, is that she was able to do that and just use these same expressive components for just a totally different purpose.
Yeah.
And it seems as Sandra was saying, so much harder when you're looking at these two images if you're just a lay person or a generalist judge to understand exactly what artistic choices went into creating the first photograph, for instance.
Yes. Yeah. Yeah.
So I think the other thing that comes into this is too the more sympathy we sort of have for a transformative use where you are actually commenting on something below, right?
Yeah.
On the underlying work. One thing I want to know is whether Andy Warhol just didn't want to take a photograph of Prince, right? Like, couldn't he get him to come to his studio is one legitimate question to ask, right? And I think that came out in the oral arguments at the Supreme Court. Not like, couldn't he get him to the studio, but there is a licensing market for this.
And I believe another fact that came out at argument is that Andy Warhol, in fact, began taking photographs of his subjects at one point.
He did. He was sued repeatedly by artists for using their photographs in his artwork. He knew what he had to do when he wanted to use another artist's work. It wasn't a mystery to him. So, and he did in this case, right? He was not aware of what the licensing relationships were, but Vanity Fair gave him a photograph and said, do this, right? Do your stuff. And he did. And part of the problem that we have here too is we don't really know what the story is in between him getting the photograph, the Goldsmith photograph, and then the series, the Prince series emerging. And one thing I want to know is we've got 16 images and nobody ever actually analyzed all 16 images. And don't tell me that a big line drawing of Prince is going to be analyzed exactly the same way as orange Prince and purple Prince is going to be analyzed under fair use or substantial similarity either, right? And so if you do, tell me why, right? I want to understand all of the reasons why. And there are other scholars who say this, and like Pam Samuelson is one, Rebecca Tushnet is one, and I don't typically agree with them, and I don't agree with them fully on these issues either. I would not have signed on to the petitioner's brief, the scholars' brief supporting the petitioners, because I didn't agree where they took the argument, right? I agree that a substantial similarity analysis should have been done, but I think their point was you should have done the analysis to be done with the case early, right? And maybe that's right. Maybe you should have done the analysis and you would have realized, oh, okay, Warhol wins. We don't need to go further. There is no substantial similarity. I would have been fine with that if you did the analysis, right? But I'm not prepared to sort of say that in an amicus brief and presume that without somebody having done the actual analysis, right?
Professor, I'd like to challenge you a little bit on that, whether this is the right case. Because when I say, first off, you have admitted access, you don't really need the expert analysis looking for similarity. You've got it admitted. When I see those two images, I see something that I think it's summary judgment substantially similar. I don't think you really even get to a jury. So I really wonder if it would make a difference to have done the substantial similarity. And really, as far as the author's story, don't care. It's basically based on side-by-side comparison between the allegedly copied work and the accused work. So I guess I'd throw that out as sort of the counter.
So sorry, you don't care to hear
I don't
the
care to hear his
original author's
revisionist
story.
argument about how he came to this or what great social message. And I guess I'm looking at the kind of orthodox approach that's usually done for copyright infringement, where you take a look at the two images, particularly if you have access already. So you have enough to show copying in the sense that, there's no independent of refuting independent creation. It's generally a visual analysis. And I think in this, I kind of wonder if the court wouldn't find that on summary judgment to be substantially similar.
Maybe they would, maybe they wouldn't, but they didn't do the analysis is the
Well,
point.
yeah.
So,
But, you know, okay, thanks.
We need a mic.
Um, I think that there, copyright, as we all know, is extraordinarily complex and difficult. And I'm going to comment a little bit on the question that was just asked. And I like to break it down to, was there a copy? And in deciding whether there was a copy, we look at substantial similarity. And now okay, yeah, it's substantially similar. And to me, is this a copy? Okay, it's a copy. He copied something. Now we move on to derivative work. And have they added something? Well, added orange. Is that sufficient to make it a derivative work as opposed to just an infringing copy? Then when we get past, oh, it's a derivative work, we're still saying, well, now you're infringing the derivative work right instead of the copying right. And now we get to fair use. So I would have liked to have seen, those 3 steps laid out clearly, but we know that the courts are doing a horrible job. They just jump straight into transformation and they say, oh, we're done. And so I think that's a real problem. And my question after all of this is, how do you see the transformation in terms of the subjective intent? I look at these 2 pictures. I can't tell what the intent of either one was. I have an emotional response. It's not like, if you will, the 2 Live Crew case where, okay, they've changed the lyrics, they're making fun of the pretty woman, they're doing all that stuff. And the 2 Live Crew didn't really have that intent that the attorneys put on them later on, but I can believe that was actually there. I can believe a lot of things. I'm a lawyer. But in this one, I can't see anything that takes us into where we can judge an intention. So how do you go at your intention in terms of subjective? I don't think it matters that Warhol was trying to send a different message if I can't know really with a degree of certainty, objectively, I hate that word, what that intention was.
Yeah, we totally agree. We think the subjective intent in the form of, after the fact testimony is not and should not be relevant to the transformative use analysis, but rather that it should be judged from the perspective of an objective observer. And to take another, visual art on a portrait example, in fact, that I think is a nice counterpoint to this one is the I don't know if I'm pronouncing it right, but the Keenitz case from the 7th Circuit cited in our brief, if you would like to look it up. But where you had an image of a city mayor that was taken to celebrate his inauguration. And then what the artist did was, yes, they changed the color. They made his face green, but they also added to the image, added words that were criticizing his politics. And so you don't need to go into subjective intent. It's apparent to the observer that work is serving a different purpose, has transformed the purpose of the original work.
Yeah. And, just to pick up on John's point, I think that once again, John is also like agreeing with us, but it's a different stage. In other words, if I read you correctly, John is saying that if the court did do a substantial similarity analysis, it's a slam dunk. That these are obviously, and I think what you've been saying is, okay, so let's do that. Let's do that and then move on to whether or not this is a fair use. Because of course, if it's not, copyright doctrine 101, if there's no substantial similarity, then there's no need to have a fair use conversation. Exactly. Yeah. Yeah.
And I think, I don't want to put words in Sandra's mouth. I'll let you explain it. But I think one point you've made to me, at least, is that the substantial similarity analysis allows a judge or a jury to evaluate the 2 images from one perspective, and then the fair use analysis allows it from a different perspective.
Right.
So this also folds into your question.
Exactly, and that's a point that I was going to make, if I had the opportunity, and thanks for that. So, I think that's a very important procedural point that shouldn't be overlooked, and people say, and that's one reason why maybe I disagree with Lateef's approach and your approach a tiny bit, which is I don't think everything should be folded into the fair use defense, because I think it is important for both parties to have the opportunity to present kind of their case framed from their perspective. And so when the burden is on the plaintiff, in this case, not the plaintiff, when the burden is on the first artist, right? It's the first artist's opportunity to say what is substantially similar about the two works, right? And so you're looking at the two works, and the literature in the cognitive sciences sort of tells us it shapes our understanding what you offer as the first image to compare against the second, right? So you say the father looks like the son, not the son looks like the father, right? So if I'm going in as the plaintiff, I want to be saying like, this is my work.
Yeah.
Andy Warhol's work looks a lot like my work, right? And here's why. And I want that chance, right? I want the court to hear my perspective, right? I don't want that taken away, and the whole case to be framed as an affirmative defense, as Andy Warhol coming in and saying, I am the brilliant artist, Andy Warhol. I added so much new, original, valuable to society stuff, which he did. I'm not denying that, but that's how it's framed, right?
Yes, exactly.
And so you never hear the story of the original artist, right? And deny that person their day in court. And so it's valuable from both sides.
Yeah, and that's why the sequence is important.
Yes.
Right.
Yes.
And that's why also what you put in the brief in terms of, okay, who should be making this assessment?
And exactly right. So substantial similarity is judged by the ordinary observer. And I will, I'll put a little modification on that as well. There's like the sophisticated observer, which is not necessarily somebody with better taste, but somebody who sort of can, in their mind, supposedly grasp the protectable versus unprotectable elements in a work without somebody having to come in and like dissect this work into elements that will make it impossible to understand as a piece of art, right? So that's one thing that I sort of disagreed with Ian Ballon on this morning when he was saying in his presentation that the software cases are give us some indication of how like style and so forth should be understood. No, software cases specifically talk about dissecting. There's specific tests, right, for substantial similarity that are, that do dissect case works by their elements, because it is presumed that we are not able to understand them until we dissect them.
Exactly.
Right. And we don't do that for other types of works.
Right. So I guess we have time for one more. But I know we're a little bit over, but we had some tech challenges.
Professor Jamar has helped me put the mic on. Bill Thomashower from New York, and my addition to this is I'm on the NYIPLA, New York Intellectual Property Law Association group for amicus briefs, and we did submit one on this. I didn't work on that brief. I worked on the Jack Daniels trademark brief, and I have a view about that. That's for another conference on parity. But on this one, I'm not bound, even though I'm on the committee. I didn't sign the brief. I'm not bound by what they said. Their brief was not in support of either party, but somewhat in line with what I'm hearing from the panel. You don't just look at substantial similarity. Yeah, that's if it's a summary judgment case, and maybe you have that. But now there are these affirmative defenses. It's substantially similar, but maybe it's a fair use. And how do we judge that? Not just transformation. And as the NYIPLA did write, and I think I heard it from the panel, I think Professor Mtima said, not every artistic variation is sufficient to make it not derivative. And as Professor Jamar said, if I can synthesize, derivative is also infringing. So you need to go deeper. And I am hesitant to get into a battle in front of the jury over whose subjective intent counts. I think that's a little dangerous. I love the example that Professor Jamar says that if it's a clear parody, Two Live Crew, whoever it was doing, they did Pretty Woman. Yeah, so Roy Orbison, Pretty Woman, it's different, okay? So that was clearly parody. If you can see it, that it's a parody. This, you can't see where this is parody. You're not really sure what's going on. It is substantially similar, so it makes it harder. It's in the same sort of category. They're both artistic, or one's on the cover of a of a magazine. So our brief basically said you need to go deeper to get all these things sorted out. And I like the concept of saying, well, if you've really converted the purpose, a Campbell's soup can, now that's pretty clear. Okay, that's the whole, now you're on a whole different level. These are both somewhat artistic. Now we have to look deeper. And to do this on summary judgment or a motion to dismiss, I mean, I don't think that's correct. The record, I agree with Professor Aistars, the record is incomplete here. Thank you.
Oh, yes, great. I didn't see.
We have one question on the Zoom, which
okay.
Lateef, you probably can't see from there.
No, I can't even see from like here. So
It's long. I can read it if we have time.
let's see, because
I mean, we could summarize it. The question, and thank you to the person who asked this, is about bringing us back to the social justice questions embedded in this area, and they raised the example of Hank Tillis Thomas, who I'm not familiar with, but their description is that he has appropriated the works of several significant yet historically under-recognized South African artists, and his claim is that what he's doing is entering in a dialogue with those works, and our understanding of transformative, how does that come out in the case of someone like Hank Tillis Thomas? And Lateef, I think this is along the lines of something you've thought about a lot. I didn't know.
Yeah. Like you, I'm not familiar with this particular work, but succinctly, and especially since we're almost out of time, I would say that, well, that's what they all say, right? After the fact, you can always say, well, I was trying to do this, I was trying to do that, unless you screw it up. Like, what's the case I'm thinking about with the guitar? It was on the screen there, Carrier, right? And you just screw it up and just say, I wasn't thinking about anything, dude. But if you have proper representation, right? Exactly. We didn't go through that, right? Exactly. So that's why the objective, ordinary observer, right? Because in those cases in which it's supposed to be a specialized observer, well, it's the party who has the burden of the proof who has to demonstrate why this is not the type of work that ordinary people would be able to appreciate what's going on here, right? But you don't just get to claim that. I mean, this is art. This is a photograph and a painting, right? Regular folks can look at that, make the substantial similarity determination, and then you can give them the question of facts involved in the fair use analysis, assuming we have found substantial similarity to begin with.
And I think when you get to that the fair use question, at least the transformative component, right? Again, without being familiar with the specific works, if the idea is that you're in dialogue with a work, that suggests to me that you haven't subverted, subordinated, or extinguished the message.
Exactly.
You've just added your own on top of it, but while still using the exact expression of the original work. And so maybe you can turn to section, is it 103? I'm betraying myself as a patent lawyer here. But I believe it is section 103 of the Copyright Act. You can get your own copyright on the portion of the second work that you have actually contributed. And so perhaps that would be available to someone like Mr. Thomas, but you still have to get permission or a license for the original work and your use of it.
Yeah.
I guess the only other comment I would make is that in terms of artistic dialogue, there are sort of conventions in the art world that actually prevent very many of these suits from coming to the forefront here. You don't see all that many art cases being litigated because there is a convention in the art world. There is dialogue amongst artists, and matters aren't litigated unless an artist actually feels that their work has been appropriated wrongfully from another. So I sort of do take some notice if an artist who has grown up and practiced in that convention, in that space where people do interact with each other and comment on each other, paint, learn to paint from reproducing other works and so forth, suddenly feels like their work has been violated and feels that the need to speak out. So there's something to be said there.
Yeah. Well, fantastic. I think that's, we could do this for the rest of the day, but we have an even more incredible panel coming right up. Last word to you as our moderator, Sachi.
Just thank you all for your time and thoughts. It's been a pleasure talking with you all and working with you, Lateef and Mel, on the brief. So we'll all wait eagerly to see what the Supreme Court has to say about it.
Here we
Thank
go.
you.
Great. Thanks very much.